Assalamu alaikum and hi everyone. I'm Dr. Fadila from the Faculty of Sharia and Law, Islamic Science University of Malaysia, USIM. Okay, so in this video, we will talk about expropriation. As we know, expropriation is one of the standards of protections contained in international investment treaties. Generally, investment treaties protect investors from expropriation without compensation. There are many issues that arise from this protection. Primarily, what does it actually cover? Or, in other words, the extension of protection against expropriation without compensation. For this, our reference is the text of the investment treaties themselves. However, as you may know, there are at least 2,897, according to UNCTAD, bilateral treaties entered into by countries and a number of other multilateral treaties with investment provisions. Okay, let us take an example of the UK-Malaysia BIT in its Article 4 on expropriation. It says, investments of nationals or companies of either contracting party shall not be nationalized, expropriated, or subjected to measures having effect equivalent to nationalization or expropriation in the territory of the other party, except for, okay, now we will look at the conditions. But before that, it covers two types of actions. One is nationalization or expropriation, that is called as direct expropriation, and the second one is measures having effect equivalent to nationalization or expropriation. So this is called as indirect expropriation. Okay, for a quick note, direct expropriation involves the transfer of title, just like the cases that we saw in the 70s and 80s relating to nationalizations of oil companies, etc. While indirect expropriation involves takings that destroy the economic value or deprive the ability to manage, use, control the property in a meaningful way. Alright, so let me show you examples of regulations challenged for expropriation. We have in the case of Pope and Talbot, introduction of export quotas; in S.D. Myers, banning of export of PCB waste; in Feldman against Mexico, denial of benefits of tax refund for the exportation of cigarettes; and in the case of Chemtura against Canada, the banning of linden for use as a pesticide. So there are many other regulations that were challenged in investment tribunals. You will get to see them when you read those cases. If you look carefully at the provision, there is a qualification that there could be non-compensatable regulatory measure if the measures taken are, if you see that in orange, for public purpose and related to the internal needs of the expropriating party. And the next limb provides on how compensation is made. So here it says it should be prompt, adequate, and effective. This is known as the Hull formula on compensation, which is incorporated in this treaty. Another example that I want to show you is the CAFTA-DR 2004 treaty, a free trade agreement between Central America, the Dominican Republic, and the United States of America. This treaty contains investment provisions. If you look at the treaty, the provision, it covers direct and indirect expropriation. Notice the usage of the words direct and indirect. It also contains the Hull principle, and it has two other explicit conditions. That is, for lawful expropriation, it has to be in a non-discriminatory manner and in accordance with due process of law. What is extra about this treaty is that it has an annex that states the application of customary international law and the detailed guide to determine indirect expropriation. The last example that I want to show you is the North American Free Trade Agreement, NAFTA, in its investment chapter. It similarly uses the words direct and indirect for expropriation, and it further has the extension of the provision or take a measure tantamount to nationalization or expropriation of such an investment. measures tantamount to. Take note that there are many NAFTA cases that have been brought to arbitration, and this provision was numerously articulated by the tribunals. Further, it also states in terms of compensation that it should be of fair market value, and this will be discussed elsewhere when we discuss on compensation. That is all for today's video. We will meet again in the next videos with more aspects on international investment law. Bye.